I think the rate making process, the rate making authority of PURA is one of the hardest things to get your arms around, because folks see that a entity has filed for a rate increase with us, and they don't understand that in some respects, PURA is legally obligated to provide the utility with at least a portion of the requested relief. So the U.S. Supreme Court created some precedent that has been pretty pervasive throughout the utility regulatory industry for the past, I don't know, almost 100 years at this point. There are two key cases to understand. They are shortened to HOPE, so it was Federal Power Commission versus Hope Natural Gas, and then there was a second case, Bluefield Waterworks and Improvement Company versus Public Service Commission of West Virginia. So for short, they're called the Hope and Bluefield cases. And those two cases engendered the principles that a regulated utility is entitled to a reasonable opportunity to recover their prudently incurred costs. And the second key parameter here is that a regulated utility is also entitled to earn a fair and they have to have the opportunity to earn a fair and reasonable rate of return on their capital investments. So in short, if a rate increase is filed with PURA, we have to evaluate it under those two standards, along with any standards that the state has codified through state statute. And the utility, if they demonstrate, through substantial evidence that their expenditures, were prudently incurred costs, and if they demonstrate we have to set their reasonable rate of return, those are recoverable costs from ratepayers. So that is the balance that the authority is charged with striking. And there are, companion tests that go along with that, like the Prudency standard. That's evolved over time and it's applied differently in different jurisdictions. But at its core, like what you're doing as a regulator is judging whether the investment at the time that it was the cost was incurred or the investment was made. You're judging whether that was reasonable based on what was known or knowable at the time. So you're not applying hindsight. You're not judging the utility against like what you would have done knowing what you know now. You're really looking at, did the utility do something that a reasonable utility manager would have done, acting on information that they either knew or should have known. So those are the, kind of the biggest standards that go into utility regulation, is, judging the prudency and the reasonableness of utilities' actions. And there are, of course, other standards that we evaluate utility conduct against. But at its core, when you're trying to understand why did PURA, or if you're in another state, like why didn't the Public Service Commission grant a utility an increase? Why didn't they just flat out deny it? The answer is because we're all bound by U.S. Supreme Court precedent to evaluate a request under those parameters. So, of course, different circumstances generate different results, but I think those are some of the key takeaways.